adequate funds to the state governments for increase of strength of judges from the existing 10 to 50 judges or 1 million population.
Mr. Chairman, sir, through you I would like to inform this august House that it is true that as of now the judges per population ratio in the country is low. There have been a number of reasons for this. In March 2002, the Supreme Court directed the government to take steps to increase this ratio so that pendency of cases could be addressed and people of the country could have early and affordable and expeditious justice. So we have made some progress in that direction. From the then ratio of about 10%, today that ratio has come to be 15.47%. It is true, sir, that the ultimate target has been to have this population ratio much higher at 50% of the current strength, but so far we have had only partial success, and there have been a number of reasons for this. However, sir, I must inform this august House that only recently I have myself requested the Honorable Prime Minister, as have the Chief Justice of India, that we must have an exponential expansion of judges in the subordinate judiciary where the highest number of cases are pending. And the current suggestion is that we must at least double the strength. So today the strength of judges in the entire country is about 18,900. That includes subordinate judiciary, which is 17,800 odd. We need to double the strength of the subordinate judiciary because the number of cases pending in the subordinate courts is about 2.7 crores. So I am given to understand that although no decision has been taken so far, government will look most sympathetically to this request made both by the Law Ministry and by Honorable the Chief Justice of India. So today the situation is that there is a system of appointment of judges in place which flows from the 1993 judgment of the Supreme Court. There is a view in the country, cutting across political spectrum, cutting across various divides, that perhaps the time has come when we should revisit that system. We are working at the proposal, sir, and I do hope that before long we will be able to propose for consideration by this august House a system that would ensure expeditious filling up of vacancies. Today in the High Courts there are 278 vacancies, about 30% of their strength. In the subordinate courts there is a vacancy position of about 20% of the strength. This is unacceptable. This needs to be corrected. But I would like to assure this august House, through you, sir, that government is fully seized of the matter and taking initiatives in that.
Second question.
Sir, I am seeking your protection because the supplementary that has not been replied. My specific supplementary question was whether government will take up any national program for extending fund to the states for filling up of vacancies of the judges and to increase the strength of the judges in different courts. That has not been replied.
Well, I would answer that question. Sir, recently a judgment has been given in Bijmohan Lal's case where the court has said that we must increase the strength of the subordinate judiciary by 10%. We are doing that. We have already appropriated funds given by the 13th Finance Commission towards that end. It is true that we need to support the states financially. We did support the states in 2011 when the matter was finally decided by the Supreme Court. They gave us 1 year time to make a transition. So the issue was who will fund the increased expansion of the physical and the human resource infrastructure of the judicial system in the country. So it has been like this. Law and justice is a state subject. Traditionally, states have funded it. We recognize the need to assist the states, and so we have in the past done so. Even now, we will take on board what the requests are. Eventually, it has to be funded by the states in the present scheme of things because that is a state subject. However, we have been in the past making provisions. 11th Finance Commission, for instance, has supported The funds from the 11th Finance Commission supported the expansion of the lower judiciary. Then the central government, by itself, under centrally sponsored schemes from 2005 to 2011, supported it and funded it almost entirely. But as some states, the states have to take on responsibility. We will be in engagement with the states and ensure that inadequacy of funds will not hold up the expansion of the judicial infrastructure in the country.
Thank you.
Thank you, sir. My second supplementary is, in view of the growing demands of the states for setting up of circuit benches of Supreme Court in different state headquarters, whether the government will again request the Chief Justice of India for review of the full court decision of 18 February 2010.
So this is a vexed question, and it's a vexed problem. Not because there can be any fundamental objection to the proposal to have the benches of the Supreme Court in different parts of the state. There have been demands in the past, and these demands keep recurring. However, sir, in terms of Article 130 of the Constitution, the decision to have a bench of the Supreme Court in any other state is left entirely to the discretion of Honorable the Chief Justice of India, who in consultation with the President takes the call. Now the 18th February decision, to which my Honorable friend referred to, is a conscious decision of the full court of the Chief Justice not to go in for benches. They may have their own reasons. These reasons have not been communicated to us, sir, but I suspect that the reason is that the general view in the court is that the integrality of the Supreme Court should not be diluted by setting up of benches. This, I believe, could be a reason. However, these matters will keep coming up, and I think we are going to be having this Conference of Chief Justices and Chief Ministers in April, sir, and we would like to mention this subject once again, what the Chief Justice thinks about it in the matter, and depending upon what the Chief Justice decides, we'll move forward.
Dr.